Good evening, everyone, and welcome to the Hillsborough Township Planning Board meeting of October 5th, 2023. Please join me in a salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2023 annual meeting schedule and amended meeting dates have been provided to the officially designated newspapers. Township clerk posted on the township's website and available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website, and complete applications are on file or available at the Planning and Zoning Department for inspection according with the public meeting notice. With that, may I have a roll call of planning board members and also board and township professionals, please?
Mr. Delcor is absent. Mr. Wagner?
Here.
Mr. Peason?
Here.
Mr. Scobo?
Here.
Ms. Smith?
Here.
Mr. Radowitz?
Here.
Committeeman Ciccarelli?
Here.
Mayor Lapani?
Here.
Vice Chair Julian?
Here.
Chair Sirachi?
Here.
And Mr. Coyce?
Here.
Mr. Bernstein?
Here.
And myself and the videographer are here.
Okay, thank you. Okay, we do not have consideration for meeting minutes, but we do have a resolution for consideration. Hillsborough 206 Holdings LLC with a file number of 18-PB-07-MSPV. It's an amended site plan, or the amended of the 2019 site plan occurring this year. So may I have a motion to approve?
I'll make that motion, Mr. Chairman.
Second.
Thank you. And Mr. Scobo seconded.
Not make the motion, did not second, he was not present.
He's not present. Okay.
I'll retract that, thank you.
Second.
Okay, thank you,
Who made
Mayor.
the sec- Who made the second?
The mayor.
The mayor? Yes, he's eligible.
Okay, so would you like to state who are the eligible members to vote?
Eligible members are Mr. Peason, the mayor, the vice chair, and the chair.
Okay, thank you. Is there any discussion from the dais? Hearing none. Roll call, please.
Mr. Peason?
Yes.
Mayor Lapani?
Yes.
Vice Chair Julian?
Yes.
Chair Sirachi?
Yes. Okay. We do not have planning board business. We do not have considerations of ordinances, so we will go to business from the floor for matters not on this evening's agenda. If anyone would like to comment on any other items other than warehouses, directly or indirectly, as stated in the past, because we have a number of those active, including tonight and in the pipeline. We want to get all those comments officially on the record. Okay, seeing none, we are moving on to public hearing. I'm going to take it slightly out of order. There's only one way to take it out of order since we only have two this evening. I'm going to start with the Toll Brothers with a file number of 21-PB-10-S/MS/SP with a time of decision of October 31st of this year. Let's see. So it looks like here the applicant is seeking a retroactive one-year extension through December 9th of this year to perfect the minor subdivision approval, and which was granted by planning board resolution, which was memorialized June 2nd of last year. So with that, Counselor, I'll turn it over to you.
Thank you, Mr. Chairman, members of the board. Richard Hoff, a law firm of Biscayne Hoff. I'm here on behalf of the applicant, Toll Brothers, Inc. As the chairman noted, this application for minor subdivision extension pertains to the Royce Brook development. As the board will recall, back in 2022, we were here with two applications with respect to that. The minor subdivision, which took the Royce Brook large parcel and carved it in, made 2 lots, 3 lots. That was the minor subdivision. That application accounted for about 15 minutes. And then we spent the next 3 months dealing with the major subdivision of the toll portion of that project with the single-family units, and we dealt with drainage, and we dealt with none of that as it relates to the Toll Brothers major subdivision application is being addressed here tonight. The only thing we are seeking an extension of is the 3-lot minor subdivision that we obtained in connection with that project. So that's all we're doing. The 3 lines that were the new lots that we were creating to pave the way for that major subdivision. Under the municipal land use law, a minor subdivision needs to be perfected within 190 days. It's just a different provision in the statute. It envisions, obviously minor subdivisions, small tracts, easy to perfect. This obviously was a little more complicated. It requires the minor pave the way for the major, and Toll Brothers is the contract purchaser. The perfection of the minor subdivision is not going to occur until all the conditions associated with the major subdivision on the one lot are perfected. And we are in the process of perfecting those approvals, but we are not there yet. We have some outstanding outside agency approvals that we're waiting on. The chairman indicated we were seeking an extension of the minor subdivision until December of this year. We would actually like, with the pleasure of the board, to extend that further to run contemporaneous with the major subdivision approval, which expires on June 2nd, 2024. We'd like the minor to run to that point in time. We're hopeful that we can perfect by that point and record it, but if not, it'll be run contemporaneous with the final approval that if we're not under construction, we need to be back to this board anyway to extend that one so we could deal with them all at the same time and having them running at the same time instead of having different approval end dates. So our original application, when we filed this in June, we were hopeful that we would be further along with the outside agencies. Unfortunately, it's taken a little bit longer. So again, with at the pleasure of the board, we'd like to amend the application to extend this application for the minor subdivision to run to June 2nd, 2024, which is the expiration for the major subdivision. So that's the basis for the request for relief. I'm certainly available to answer any questions from the board, members of the public. I have our representative and our engineer here, but as I've indicated, we're not amending any aspect of the Toll major subdivision with this particular application. Thank you.
Thank you. Anything, Mr. Bernstein?
I think if the board has any questions of Mr. Hoff, otherwise open it up to the public on the limited nature of the request. You want to be heard on something?
I do. Members of the board, I represent Central Jersey Regional Airport. Mr. Horner called me this morning after he...
Mr. Ogrodnik, though you are a regular here, you might want to, for the sake of the record, indicate who you are and by who you represent.
My name is Mike Ogrodnik. I'm an attorney at Savoshock Law Firm in Somerville. I was contacted by my dear friend Joe Horner this morning, and he asked that I appear to just place something on the record. After the Canal Walk subdivision was approved and constructed, Central Jersey Regional Airport was getting quite frequent complaints about their takeoffs and landings. And I further understand that a requirement of this applicant and this developer would require what's called a Planned Real Estate Full Disclosure Act, which is a New Jersey statute codified 45:22A-21. And we're asking that this board impose a condition that provides language under the community information section of the disclosure under subsection location and uses of surrounding property to include as a condition of this resolution, as well as what's required by the Full Disclosure Act, language that states as follows: Central Jersey Regional Airport is located adjacent to the subject property on Block 183, Lot 17, otherwise known as 1034 Millstone River Road, and is on a 119.46 acre parcel. The airport has approximately 150 aircraft with approvals for more hangars based upon on the field, and generates approximately 175 takeoffs and landing per day, which may increase over time. I've spoken with Mr. Hoff today, and
We have no objection to the language.
For the purpose of the record, Mr. Ogrodnik, you're here on behalf of your client, Central Jersey Regional Airport?
correct.
Thank you.
And I'll email this legal letter in tomorrow.
An applicant has no problem in placing that condition on an approving resolution?
Yeah, that's fine. I mean, I don't know that it impacts the minor subdivision, but for practical purposes, Toll has no objection to including that in its disclosures to third-party purchasers.
Thank you. Unless the board has any questions of Mr. Ogrodnik or Mr. Hoff, there may be a motion to open to the public for the limited purpose of this request made by Mr. Hoff for the extension on the minor subdivision approval.
Okay. And Mr. Grodnick's request? Is that,
Mr.
Jermaine?
Hoff has indicated that Mr. Ogrodnik's client's request is acceptable to his client and therefore would be a condition to to a resolution approving an extension.
Okay.
And Mr. Ogrodnik, I assume, will send everybody the necessary information, so I make sure I put it in if that's what happens. Thank you,
Okay.
Michael.
Mr. Coyce, anything before I go to the board members?
I have nothing to add.
Okay.
Thank you.
Board members, anything at this point?
I want the record to indicate that while Mr. Scobo is on the dais, he is recused from this application and is merely sitting there quietly minding his own business, but I want the record to reflect rather than him walking out into the audience only to walk back later.
Okay.
So,
Thank you. Okay, so if no current comments at this point. I would entertain a motion open to public.
So moved.
Okay, all in favor?
Aye.
Aye, okay. If there's anyone in public that would like to comment, question on this request? All right, and it's limited to the extension, not to anything else in that application?
Nothing Mr. O'Brien said.
No.
Okay,
Bottom.
Okay.
There you go. And state your name and address for the record, please. Thank you.
Susan Gulliford, Hunt Club Road. You stated some approvals were holding up, perfecting it due to outside agencies taking a little longer. Could you be specific about which agencies are holding it up?
Sure, we're currently awaiting approval of flood hazard from NJDEP and DRCC.
Okay. And what Mr. Ogrodnik said, we can't, that's a separate item from their request?
Yep.
Darn, I didn't know. Thank you.
Tom O'Donnell, 33 Ann Street. Trying to keep to the agenda on the subdivision. Is there provisions in the subdivision, the minor subdivision for the 340 acres that's going to protect the remaining 304 acres as far as use and impervious surface and contributing to, and further adding to our concerns about stormwater runoff and issues in Claremont community?
The minor subdivision had no actual improvements proposed by it. The improvements are proposed by the major subdivision application, which is not the subject of the present request for an extension.
So what you're asking for a request doesn't have any governing language that limits the use of the 304 acres in the future?
It has no limitation on any use because it doesn't approve a use. It merely changes boundary lines of lots.
Okay. The other question I have is, a little confusing on the letter I received, which, and then the agenda for tonight, is the agreement as it is today, is that null and void? Because it looks like it, if I'm reading this right, it expired on December 9th, 2022?
The time for which the recording of the minor subdivision would have had to have happened was December 9th, 2022. The municipal land use law allows that date to be extended at any point thereafter when the impediments to recording are removed, in this case, the outside agencies. So we could come back to the board after all outside agencies are approved and ask for it to be moved forward to that date, but for sake of just, expediency, we wanted to run contemporaneous with the other approval, which is the major subdivision, which is why I'm here today, as opposed to at the end of the process. So you're correct, under the statute, the 190 days has already run, but the statute also allows for that date to be extended after the fact.
So this is a comment for the dais here. I understand that this is separate, but it is still the same land is owned by the same landowner, okay, that has a lot of issues with their larger, major subdivision. And it seems like, again, we're asking for approvals. The dates are a little confusing from a landowner that's been pretty reluctant to comply and support the neighboring community. And part of the approvals is related to that project because it says here, somewhere in here, something mentions driveways and parkways. Driveways and parking being reconfigured, which is clearly connected to the major subdivision, correct?
It's connected to the major subdivision. It is not connected to the minor subdivision. And I'm not attempting to be coy. What we did with this application was, the first step was, there currently exists 2 lots that make up Roycebrook Country Club.
I know.
So to allow for the Toll Brothers portion to move forward, we created a 3rd lot, and upon that 3rd lot, we had the major subdivision for the single-family homes, supportive infrastructure, roads, everything that we talked about over the course of those hearings. But the first part of the application was that creation of the 3rd lot and this minor subdivision. All we're doing is extending the time for which to record that. We're not doing anything on the major.
Understood. So it's all, in my mind, and I'm not, obviously, I'm just a neighbor here. From my perspective, a special zone was created, if I'm not misunderstanding this, for this project, Roycebrook, whatever zone. Independent of the approval or part of the approval, or what I'd like to have the planning board start to think about is protecting the remaining 300 acres, which is this minor subdivision that they're just talking about changing the lines a little bit. Because it's, 130 acres with very high impervious surface that is coming out of the major subdivision. We'd like to see the minor subdivision protected in some type of a use limitation so that we don't have even more impervious surface added to the neighbors, the property sitting next to our neighborhood. So that's my comment and request.
Mr. Bernstein, correct me if I'm wrong, but before anything could move forward, there would have to be an application. So that would be the appropriate time.
Well, there has
To
been an
review that.
application. The issue is there needs to be approvals,
Right.
but as part of the application this board approved last year, that was all to be addressed pending review by outside agencies.
Right.
So the issue of stormwater management and related items were addressed in the application that the applicant brought as the second part of the overall application, and that's subject to their proposed remedies or proposals relative to such are subject to the review by NJDEP.
So,
And the other application is before this board and not a subject this board can discuss.
so really, it's up, it's right now in the hands of the outside agencies.
Correct.
Okay. Okay. Any other? Got one more.
Doug Eden, 55 Ann Street. I would like to ask if the well drilling that was going on today had anything to do with this application.
It's not what this application is about.
Does this application,
It's not what this man is here before to answer that question. This is strictly about the lot line change.
okay.
This
Then-
application proposes no development.
Okay, but today there was well drilling going on the golf course at MW4, and I was just wondering if that had anything to do with this application.
It has nothing to do with this application.
Okay. Does stormwater have it part of this application?
No.
So what was, you were saying before something with stormwater was holding something up?
We needed outside agency approvals from the NJDEP and the DRCC, and stormwater review is part of both applications.
So the stormwater application is current?
It's pending, yes.
It's pending?
Yes.
So what you're using in your stormwater application, from what I understand, you got it in prior to the changes in the state. So now there's been changes. So if they give you an extension on this application, would that have anything to do with?
It would have no impact because this application doesn't propose any stormwater regulations. That's the major subdivision, not the minor subdivision.
Okay. So that application, so I understand, the stormwater application could still be, since it's still pending, could still be changed to where you would have to use current data?
No. The applications were submitted prior to the change in stormwater regulations adopted by the DEP.
Okay, so you're not asking for any extensions on that?
No, it has nothing, this application has nothing to do with any aspect of that major subdivision.
Okay, thank you.
Sure.
Evening. Tim Baracco, 3 Franklin Drive. I don't know if I can ask this question, so let me just ask it and see if I can go forward. You mentioned, Mr. Hoff, that this extension was tied into the flood hazard area permitting that's coming from the DEP. They're reviewing it and so on.
I said the application is being sought because of delay in receipt of outside agency approvals relative to the major subdivision, because we won't proceed with the minor subdivision unless the major subdivision is perfected.
Okay, so I guess I just didn't word it right, but where
Okay.
I'm trying to go with it is, I'm familiar with that application you guys did in June, as a layperson familiar with it.
Okay.
Can I ask any questions about it?
No.
No.
Is there a time that I would be able to ask questions about it?
We spent 3 months asking questions about it back in 2020.
No, the flood hazard application is new in June.
Oh, well, the flood hazard application is subject to DEP. If they make a decision, they publish notice.
Can I
and
ask any questions about that and what you submitted and what,
No.
As before this board, no.
No.
is there another opportunity someplace to ask questions?
As Mr. Hoff was trying to explain, his client application will be reviewed, DEP will provide basically what I'll call a tentative decision, subject to notice in the New Jersey Register, with people having the ability to make comments regarding such before they render a final decision. And I believe, correct me if I'm wrong, that if a final decision is rendered, there is an appeal process of that by outside parties as well.
That is correct.
But before this board, we're done.
Okay.
Unless DEP sends them back
Okay,
or requires them to come back because of the
Because of
change in the
changes they've
application.
required.
Yeah.
fair enough. Thank you.
Okay.
Yep.
Thank you. Any other members of the public? Okay. Motion to close? Okay, all in favor?
Aye.
Aye. Okay. Any other final comments, questions from the board?
Mr. Hoff, I appreciate the fact that you want to extend this out to make it congruent with your other application on June 2nd. I personally am kind of hesitant to give you an extension that long without seeing you or hearing from you as what the progress would be. And I don't know if the chairman or the other members feel the same way, so was there any indication as to when you might hear any information sooner than June 2nd?
I don't know. We would expect that the outside agencies will act in the next couple of months, but, DEP recently asked for a 30-day extension of review on the flood hazard. That doesn't mean at the end of that 30 days, they don't ask us for another 30 days. And then, so we would like to be, I'm just trying to save this board's time and obviously my own client's time by sending me. We would want to perfect it as soon as possible. It's obviously in our interest to proceed. I'm just looking to avoid putting this board, because as you know, Mayor, the minor subdivision really doesn't really do anything. It's just the reconfiguration. The likelihood is I'm back on the major come June 2nd for an extension of that, and we'll spend time talking about that, I suspect, and we might as well, my thought was, let's do them both then, if we haven't perfected the minor by that point in time. It would be our hope that we'd be able to do it. It's the first step, obviously, right? We get all the outside agency approvals, we record the minor subdivision, we close. Toll then is just dealing with its toll portion, and Royce Brook gets the other 2 lots, and it's carved out of it. And then we're just dealing with the toll portion at that point. That would be our hope and our our hope, not our expectation when we're dealing with outside agencies, but it would be our hope that we would have that wrapped up by June. Realistically, I don't think that's happening by December.
So can you just clarify then, in the public packet, it's saying a 1-year extension through December 9th of 2023?
Correct.
Okay.
So-
So to
Yeah, to perfect. So we would be asking that that be extended to June 2nd, 2024 to perfect the minor subdivision, meaning recorded.
Any other comments, thoughts? So are there any items that the 2 agencies are waiting to receive, or?
No, the flood hazard, we got review from DRCC earlier this week. They've asked for additional clarification of issues that ironically DEP has, but I guess even though they sit next to one another, DRCC and DEP don't necessarily communicate that well. So we'll then provide that same information to DRCC, and they'll review the same regs and make a decision. So again, we're hopeful it's quick, but it's outside agencies.
So have you already provided the information to DEP?
DEP has all the information that they've requested to date, yes.
Okay. And now DRCC's?
Now DRCC is asking for that same information.
Okay. Did they give you a timeline when they would like to see that?
No, they say it's not complete yet until we get this additional information. We'll provide that information. We only got the letter, I think, earlier this week, so we'll provide that additional information. Realistically speaking, they'll review it. We'll get on their public hearing. We're hopeful for December practically, because we get it in the end of this, this month, during this month. They'll take 30 days to review. We won't get on an agenda likely till their December meeting for DRCC.
When's that date? You know when they're meeting next?
I'm not sure exactly when their DRCC public meeting is for December, but
All right, I think we may want to just get an update to see where that, was that?
I mean, we could provide you an update as to outside agencies. We could do it, if you want it in writing. I mean, I'll come back. But if the issue is you'd want an update as of December 31st, whatever, we'll provide that if you want. Similar to what we did for, the 206 one.
I was going to say you're familiar with updates.
I'm familiar with the process of updates. So we'd be happy to do that. I could provide you an update just where things stand, sure.
What do you think?
I'd like an update, whether we get to decide, I'll leave it up to counselor if he feels you need to come back or not. But I'd like to know by, let's say, end of February, where you are.
Actually, Mr. Chairman, the thought was to grant the extension through the end of February
Right,
and have an update by the end of December.
yeah.
Is that a problem, Mr. Hoff?
No,
Okay. And then maybe I was reading. And then do we need then to also have an extension of the time of decision?
No.
No? Okay.
The lot line.
Well, that's why I was getting confused.
yeah, there's,
Is Mr. Coyce, you testing us that we read these?
I was hoping you weren't going to read that. No, I apologize if
No
there
worries.
is
No, I
errors
mean, if
in-
that's, yeah. I just want to make sure. I don't want to.
I don't see it.
Motion to extend for the perfection of the minor subdivision approval, Toll Brothers Inc., RPG, and Clay, file number 21 PB
also to add the,
As well as the requested language condition regarding Mid-Jersey or
Central
Central?
Jersey Regional Airport.
Central Jersey Regional Airport requested applicant
Okay.
I make
Don't
that
want anyone to
motion.
hear me anyway.
Okay. So the mayor made the motion. Do I have a second?
Second.
All right, before the roll call is taken, just so it's perfectly on the record, this is an extension of the request to perfect the minor subdivision approval through February 28th, 2024, with a written update from applicant's counsel's office to the planning director on or before December 31st, 2023, as to the status of outside agency approvals, as well as the resolution will contain the condition regarding the Central Jersey Regional Airport, as requested by Mr. Ogrodnik on behalf of his client and agreed to by Mr. Hoff on behalf of his. And that will not be stated per se in the resolution.
Thank you. So we have a motion and a second. Any final comments from the dais?
Sorry, who was the motion in the second?
Motion
Mayor
was
made
the
the
mayor,
motion.
second was Committeeman Chicarelli.
Thank you.
Okay. So may I have a roll call, please?
In just 1 second, I got to talk to Eric.
Call him, don't call him. Mr. Radowitz is being excused from the roll call vote because he was not present for the underlying application.
Mr. Wagner?
Yes.
Mr. Peason?
Yes.
Ms. Smith?
Yes.
Committeeman Chicarelli?
Yes.
Mayor Lapani?
Yes.
Vice Chair Julian?
Yes.
Chair Sarachi?
Yes.
Thank you very much.
Yeah, thank you. Okay, we don't need a break, right, Mike? No. Okay.
We need a couple-hour break, don't we?
Okay, we're moving into, to our next hearing.
What do you
on-
want to do, John? You want to sit here with the understatement is, or you want to go home? Nope.
No.
All right,
Okay.
why don't we give Mr. Chicarelli a minute before he,
Okay.
yeah, you did until halfway through, you woke up and said it's time to go home. You might want to call home first, John.
All right, good night, Ms. Committeeman.
All right, let the record reflect that that Committeeman Chicarelli has recused himself, as he has throughout this entire application. Mr. Scobo is back officially on the dais because he is not recused from this application, and all of the board members who are on the dais are eligible to continue to hear this application.
Thank you. Okay, up next, Homestead 279 LLC, file number 22-PB-05-S/MSPV. Time of decision of the end of this year. Appears here the applicant is requesting to be adjourned to a date certain without further notice. So this application is being continued from July 13th of this year without further notice. Counselor, the floor is yours unless Mr. Bernstein, you have anything to interject. Okay.
Put their,
Good evening, members of the board. My name is Michael Ogrodnik. I'm an attorney at Savo, Shaw, Corsini, Warner, Gillespie, Ogrodnik, and Fisher on behalf of the applicant, Homestead 279 LLC. This is an application that I filed on May 11th, 2022 for a minor subdivision preliminary and final major site plan approval for the construction of an industrial building at the rear portion of Block 200.02, Lot 12, otherwise known as 279 Homestead Road, located in the LI Light Industrial District. Tonight, the sole reason we're here is to seek a continuance to adjourn the hearing without notice to allow for the applicant to revise certain portions of the application in light of the township professionals' comments, both from Mr. Bernstein and Mr. Mayhew and Mr. Hay. Specifically, Mr. Bernstein drafted a memo dated August 25th, 2023, which opines that the creation of a condominium form of ownership divests the board from jurisdiction, with the opinion that Redcom, who would be the developer of this industrial project, would not have standing as a developer. Bernstein memo also calls into question whether revisions to the plan constitute a quote-unquote amended application as defined in the MLUL. Without getting into, I mean, I'm certainly prepared to argue that legal issue, but I think it's moot. I set forth a legal brief dated July 28th, supplemented that brief with a letter dated September 26th related solely to the request for the adjournment. And given that the applicant is willing to eliminate those two concerns related to standing and substantial changes to the plan, we're just asking for time to, again, redesign the plan to go back to a minor subdivision as was originally proposed. And then, of course, we are kind of stuck in a bit of an unknown with all of the comments that were progressively made that resulted in alterations to the plan, you know, tweaking the plan, removing some minor variances. So the applicant is requesting time to, again, redesign the project to address, you know, certain changes from Pannoni. Let's call them tweaks and less significant changes. And so for these reasons, the applicant is requesting an adjournment of this hearing so we can meet with our engineering team and put together the appropriate packages, both to this board and, again, back to DEP with perhaps a revised plan.
Good evening, Mr. Chairman and members of the board. Joseph Torriello on behalf of resident objector Sandra Iannella. I object to the request for an adjournment for several reasons. First and foremost, it completely undermines what we've been doing since July. We reached agreement on the record between, it wasn't Mr. Ogrodnik, it was an associate from his firm who came. There were several issues in this matter regarding standing. We stipulated and agreed to a briefing schedule. We made our legal arguments. The board's attorney issued an opinion dated August 25th, which I know you all have seen. And the board attorney has asked this board to undertake a vote based upon procedurally where we are. Procedurally, we are at a point where the standing issue was raised, the issues were briefed, and the parties agreed after the briefing Mr. Bernstein would issue his opinion and recommendations to the board. And certainly the board is free to ignore Mr. Bernstein's recommendations, but the understanding was that there would be a decision by this board based upon those legal arguments that the parties have made. And I believe that my client is entitled to a vote on this. The attorney has asked on page, on the last page of his letter that the board take a vote, and Mr. Ogrodnik to suggest that he wants an adjournment to go back to the original application, which was withdrawn. There has been entire testimony on that original application, and he concluded his case. And it was only after my cross-examination of his last witness that they withdrew the application because there was no street frontage, and he could not satisfy the MLUL. So, I mean, again, to go back and change again, that's why we're here with the briefing schedule, because of the constant and ever changes of this. And I think it's inappropriate. And it's prejudicial because the request is contrary to what we've agreed to. And I think the board should take a vote based upon the recommendations.
In my letter dated September 26, 2023, we submit facts related to, not to the underlying standing issue, which I couldn't disagree with more, the determination or the opinion from Mr. Bernstein that Redcom is not a developer under the MLUL. There's no case law that supports that. There's thousands of condominium units that have been found to have standing, and the one case that does address it just requires that the condo association itself consent to the application. So I couldn't emphasize more, which I'm sure Mr. Bernstein realized with my communications with him related to that opinion.
but it's moot at this point. Now, Mr. Torriello has had numerous communications through his expert, through my office, through Mr. Bernstein, as to changes that Mr. Iannella would like, okay, in this application. He requested that the building be reduced in size. We did that. He requested that the stormwater management area be changed to the other side of the lot, which changed the grading. We did that, resubmitted everything. He requested that the number of shipping bays be reduced. We did that. And again, the building was reduced, 20, 30,000 square feet. To suggest that those very changes that his client asked that reduced the intensity of this application amount to substantial changes, that now this is an amended application, I think is very disingenuous. Because again, Greg Reddington was trying to be a good neighbor and trying to work with Mr. Iannella, which is clear by the record and the site plan amendments that we made. For the issue of the subdivision is nothing to do with Mr. Torriello's cross-examination. It really related to early comments from Todd Hay when he was sitting in Mr. Mayhew's chair, when he said, and I'm quoting, "It's a very interesting case. I mean, I've seen applications for landlocked lots. It's not preferred. I know Mr. Maskey would probably agree with me on that because we've done enough cases in many years. I've not seen anything like that before, especially for a warehouse." So in response to that, I believe it was entirely reasonable for the applicant to seek an alternative design with a condominium-style ownership, which is accepted in New Jersey law for decades, if not longer, and that eliminated the Section 3536 variance for lot not abutting a street, even though we did originally testify, Mr. McDonough did testify just on that issue. All these issues are now moot because we're willing to go back. We just found out that the board attorney would recommend to the board that the applicant doesn't have standing because they're not a developer. So now we have to go back to the original plan. I don't see any reason why we would be prohibited from going back to the original minor subdivision plan.
Are you finished?
Yes.
I didn't want to interrupt. I am tired of the record being sprayed with incorrect information about the good faith nature of the discussions. From day one, my client had indicated the need to move the retention basin and not direct the water to his property. That was never in any of the discussions, in any of the plans. The core concern of my client was never addressed. And I'm not going to go through the scores of emails, and if I need to, I'll have an affidavit prepared from Mr. Mielek regarding the conversations. But the good faith discussions reached such a level, I had to send a cease and desist to Mr. Reddington, and his response was, "Your email requesting a cease and desist is not legally enforceable unless it's issued by a judge." So not only did I issue a cease and desist, but the wonderful Mr. Reddington, the good neighbor Mr. Reddington, in response to it, basically said, "Too bad. I'm going to contact Mr. Iannella even though he asked me not to contact him anymore." That's the good faith, okay? And it's in writing from Mr. Reddington. So I am tired of the inaccurate suggestions of the good faith efforts of Mr. Reddington. It's patently false. And again, we agreed on a briefing schedule. We spent months on this, countless hours. We briefed the issue. The standing issue has been before this board since it was raised by Mr. Bernstein and I have to look at my notes of which meeting. This is not new. And while I'm looking for that, the suggestion of a condominium, they've never put forth a condominium plan. The one that was put forth before this board had two owners, two independent owners. That's not a condominium association, and that's all been briefed.
Yeah, since March 9th. It was raised by Mr. Bernstein on March 9th, the standing issue. And this has been an ongoing issue. It's now October, and we briefed it.
However, the opinion letter was dated August 25th, 2023.
Right, and now you're trying to change the rules of the game like you've been doing for the last year, which was the whole basis of needing to brief this issue, because you're constantly changing things. Significant changes, which from a legal standpoint requires a new application, according to the board's attorney.
If the board prefers to argue the merits of our briefs, I've got my shark socks on today, so I'm ready to prepare. I'm prepared to argue that motion because I do take a particular objection to some of the conclusions reached specifically related to standing. So if the board needs to vote on that issue, and that may impact the applicant's course of action, we can do so. But as I said earlier, I believe it's moot because the applicant will agree to go back to the subdivision. So that the issue of standing becomes moot if the applicant reverts to the original application. There's no prohibition that an applicant cannot make changes to the plan, especially when the changes of the plan are at the request of the board and the objectors. We're just trying to accommodate comments from the professionals, comments from the objectors, and frankly, we're entitled after approximately $400,000, $60,000 in application fees. I believe that we're entitled to conclude the hearings as expeditiously as possible. I believe we're down to perhaps one or two more witnesses, but the MLUL talks about the need for this board to vote on the merits of the application. As I've said from day one, we're just trying to get a fair hearing, and we're just trying to create a record. Given the initial comments from the board engineer related to the non-preference of the original design of this application, it was reasonable to make those changes. Those changes resulted in some legal arguments. I would submit that once they're, and I put in quotations, ruled upon, that we can make adjustments to the plan. I would also note that, these issues really I think are great legal issues that Mr. Torriello raised. He's a very creative and skilled attorney. I've always been impressed with his preparation. And I think these are great arguments for an appellate court or a superior court. But for purposes of the municipal land use law in this application, the board has to render a decision. So if this board were to say, we're not going to hear you, then I think that would be problematic and expose the township to damages that are well beyond a prerogative writ. So I don't know why we can't finish, having gone 8-9 hearings and 50 hours of testimony. So we rely on the cases that I cited in my legal memorandum, and again, my September 26 memo makes the legal arguments essentially moot at this point. Again, the applicant has to preserve their rights that Mr. Bernstein's opinion that Redcom, in proposing a condominium ownership, doesn't have standing. We adamantly object to that. I think if you read the cases, there's one case on it, and I think it says the opposite. So this board, if the board were to say that this applicant doesn't have standing, I believe it would be the first time any land use board in the state of New Jersey has taken the position that an applicant who proposes a condominium style of ownership doesn't have standing. So I think that's a stretch. But again, we want to continue to work towards something that makes sense. And if that is a subdivision, I think personally, it makes more sense to have two lots. You've got a 10, 11 acre lot in the back of a bunch of industrial properties. So to me, it makes sense to go forward with the subdivision application.
One final comment on that. To illustrate the circular and dizzy reasoning in this request, to suggest to go back to the original subdivision application, on page 7 of Mr. Bernstein's letter, he says, "The removal of the subdivision and submission of the condominium arrangement alone is a substantial change that requires the filing of a new application." The request tonight is yet again another substantial change. So it doesn't change the legal reality of Mr. Bernstein's letter that a substantial change requires a new application. So the request tonight is exactly what is addressed in Mr. Bernstein on page 7 regarding the change between a subdivision and a condominium association. Your attorney has indicated that that alone is a substantial change. So the request tonight is yet another substantial change. So that is yet another reason for the board to vote on the dismissal of this application.
I just want to note that this applicant never withdrew the subdivision application.
So I'm confused. I'm just, well, because we either have a subdivision or we've got a proposed condo association with no subdivision. So I'm not sure, it's one or the other. And so, I mean, just clarification as to what are we looking.
The intent is, and again, we're waiting on tonight's decision, is to move forward with the minor subdivision as originally proposed.
So, but as far as, when I talk, with the revised plans or whatnot, the actual, I'm going to call it site plan, the building and all that, that's not changing. As the last version that we got, we're not looking to change that.
Well,
That's what I'm trying to.
It's a very good question, because Mr. Torriello argues that these changes constitute a substantial change. Now,
Yeah,
first of all,
and I
that's
don't-
not the standard.
Right, and I don't even go, because I actually questioned to define substantial change, and Mr. Torriello did not give me, any metrics to go on. What I want to know right now, are we looking to do a subdivision, or are we looking to do a condo with the last set of plans that was provided to this
So-
board?
Actually, you're looking at a third.
No, we're going to revert back to the original application concept for the subdivision.
Right, of a subdivision, but is that now rolling back the changes that you had made at the request of the objector?
Well,
Like the retention pond and the facing and the
you
shortness.
know what, I would ask that Mr. Bernstein weigh in on that, and the board, on what the board wants to do.
No, you're
No,
making a
no,
request, so I need to know, what is your request?
Well, my request is for an adjournment, so we can look at, so let's assume that there was a minor change suggested by the engineers, and we agree to that change.
Mhm.
So it's not exactly the original application. It would address comments made from the professionals, as we've proceeded through this application. So it's going to be a minor subdivision with a separate lot in the rear of the property. That's the intent.
But what has changed since the last time we all got together? From the professional standpoint, from anything other than Mr. Bernstein, talking about engineering professionals, planning professionals, what request did they make of you since July 13th that would change your site plan? And I'm not talking about subdivision versus a condo association. I'm looking at the physical site plan itself.
Changes were made to the site plan at the request of the board that reduced the size of the building,
Right.
reduced the number of bays, reoriented the building to have the shipping bays face the existing Hillsborough office park, and altered the stormwater management to put the detention basin sloped away from Mr. Ionella's property.
So is that what you're requesting, the adjournment is to address those 4
Correct.
items.
So we're going to go back to the subdivision and make whatever necessary changes we think are appropriate, given the professional comments on the application.
But were the professional comments based on the subdivision, or were they more based on no subdivision and we've got a condo association? That's why I'm just trying to.
Well, the comments from the board were initially related to the displeasure with a landlocked parcel.
Right.
Mr. Bernstein has opined that if we go down the condominium route, that we don't have standing to proceed before this board. So-
Mr. Chairman, it's on. Let us opine, since my name keeps getting bandied around as I opine. Let's opine. Opining number one, there has been a question as far back as March as to whether or not this applicant has standing before this board in regard to the original application that was provided to this board, which called for a flag lot in violation of both town code and state law. In that, not it's a violation, they can't have a flag lot, it just doesn't belong here. Here being the planning board, it belongs before the zoning board. Based on those comments, other comments made by Mr. Hay, et cetera, we got, along with comments from Mr. Torriello, we ultimately got a second application. This one, however, in a way to get around, was a two-parter. One, more importantly, was to get around the flag lot issue. Let's create some condominium ownership with basically smoke and mirrors, my words, in terms of how it was put together, whether it was real, it was draft items, it wasn't anything that you could sink your proverbial teeth into. And oh, by the way, on top of that, we're reducing the size of the building approximately 10%. We're reducing the number of bays by a few, and we're reorienting them toward the office park, all comments made by various members of the board, as well as other related items. That became the second standing issue, which is, in reality, two parts. One, do we not have a wholly new application, which is a problem, and it becomes a problem for another reason I will mention in a moment. And two, do we really have, is it a distinction without a difference for those of us who play in the legal business? Because what we're trying to get around isn't the height, the bays, the stature, which way the doors are pointed. It's the problem of there's no access to a back lot of a lot you don't own. So my opinion, and what has exacerbated the situation that Mr. Ogrodnik does mention in his brief, as does Mr. Iannello, as do I, is the intervening ordinance change by the Township Committee, rendering no longer viable, at least at the moment, subject to court review, the existence of warehouses going forward in the Township of Hillsborough. And if Mr. Ogrodnik's client's application is deemed no longer valid, whether because it's a standing issue or whether because it lacks merit, it runs right up into the no more warehouses in Hillsborough issue, compounded by the fact that Mr. Ogrodnik's client chose not to file a contesting lawsuit as to the adoption of the ordinance, which renders an interesting question not before this board and not an issue as to whether or not they have standing in a possible litigation under that. But that's not before you all. What's before you all is a standing issue, a relatively, I won't say simple, but I will, a relatively simple standing issue. Does this board have jurisdiction to hear this application? I would suspect, irrespective of what this board does tonight, that we will all be headed off at some point. Somebody, I don't know which somebody it will be, but there are three possible candidates for it that come to mind, we will be wandering ourselves off to beautiful downtown Somerville across the street from Mr. Ogrodnik's office and dealing with Superior Court, some Superior Court judge at some point in the unknown future. The opinion my office rendered is the issue, we're indicating that we don't believe there is standing. That this board, not that the application is invalid, not that the application doesn't have merit to it, but it's the wrong board to decide that issue. It belongs before the zoning board. That's the standing issue. Not whether or not Mr. Ogrodnik's client belongs before any board, but whether it belongs before this one. I realize it now runs up against other issues that complicate the situation. It also complicates, as you know, because if you determine that this is not a permitted use, forget the ordinance, there is a higher standard to meet before the zoning board under a use variance than there is the standing before you all if it is a permitted or conditional use. So now we have Mr. Ogrodnik here asking you for an extension on behalf of his client. I don't want to, for the purpose of the record, this is not an issue with Mr. Ogrodnik. Mr. Ogrodnik's firm, like Mr. Ogrodnik, is representing his client, as I am representing you all as Mr. Ianello. Mr. Torriello is representing Mr. Ianello. I'm not sure what an adjournment gets unless by somehow we're going to get a application, and this is where, strangely enough, Mr. Ogrodnik and I may actually agree. And considering the number of love notes we've been sending each other lately, it doesn't happen that often, is if the time of application rule applies to the overall application, whatever it may be, then I am not bound by the change in the warehouse ordinance irrespective of that issue. But in order for that to occur, the application has to stay here. The issue becomes whether or not Mr. Ogrodnik's client can provide an ordinance, can provide an application that really conforms with the rules that brings it before this board. The condo association, we believe, does not, because it is amorphous and really nothing more than, you all saw my opinion, you know what I've commented about it. The flag lot is still an issue, and that the other application is still here. Now, it may render Mr. Ogrodnik Mr. Ogrodnik's client in an issue relative to whether or not he can sustain an appeal if this board decides to hear this application in another form as to whether or not this board had the authority to hear that. But that's another question for another time. My question is, can we get an application here that actually conforms with the rules, isn't a flag lot, isn't a condominium association, and tries to come into some sense of conformance with what everybody else is seeking, which, without speaking up half a board, is a building that probably looks a lot like the one in front. Size, bays, acclamation, whatever. And that whatever agreement Mr. Ogrodnik's client and the current property owner need to come into that's real and that can sustain an argument that it's not just some attempt to get around what it is, then to the extent that Mr. Ogrodnik is making the request for an adjournment based on that situation, I think the board should consider that request. If all we're going to do is go back to square one, the flag lot application, and that, I believe, Mr. Chairman, is the question you was asking, for those of you English majors, were asking, which is, which building are we looking at? Are we looking at the original building, or are we looking at the new building? I'm not so sure either particularly matters if we can't get around the flag lot problem and the ownership problem and the access problem. And we don't believe, my office does not believe, the condominium proposal gets around it based on how it is currently established. If Mr. Ogrodnik wants another attempt, let me rephrase that. Mr. Ogrodnik's client wants another attempt at trying to provide what I would prefer to represent as a quote conforming close quote application, or at least one this board has jurisdiction to hear, then I think the board ought to give it serious consideration with the understanding that I think the board is looking, without the board going on record as saying it, I think the board is looking for something that looks a lot like what's there now. But if we're talking about simply taking the old application, the flag lot, changing the building from what the original proposal was to the new proposal, I'm not so sure that necessarily the standing issue has changed, because it's still a flag lot. So that's my concern. The only item, by the way, before you this evening, Mr. Torriello's comments are correct to a point, is I rendered an opinion. It's an opinion. The opinion is that the board lacks jurisdiction, not whether there's merit to the application, not whether the standing lacks because of the condominium. It's the board lacks jurisdiction because this application belongs before the zoning board in its current configuration. Leaving aside what I anticipate is Mr. Torriello's argument that no matter what they do to the application, it will be a changed application. The question is, does the board want to give Mr. Ogrodnik's client, and these are my, in quotes, one more chance, close quote. Knowing full well, as I suggest, folks, that where we are right now is, no matter where we are, is going to somehow find its way to Somerville by somebody at some point, because it's, every time we go through this, we become more and not less confused.
If I might ask a question, Counselor. So we have choice A to vote today on standing, or choice B to, at some point, receive an amended site plan from Mr. Ogrodnik's client. We see it, and then at the next meeting, before anything happens, we would vote at that point on the standing, and whether it belongs here or not?
It is possible that the board could defer the standing issue, have an amended another amended application provided to you, have your professionals look at it, and whether or not it actually can meet the conformance of being before this board. Because again, the underlying issue, folks, is not the merit of the application.
Right.
The underlying issue before this board, I'm putting this on the record for multiple and for future reference, is the standing issue. We haven't even gotten to the merits of the application. The issue is, does it belong here? It may ultimately belong here, and you all decide for whatever reasons you either like it or don't like it, and that's a separate issue. But the issue predominantly is standing right now. So it is within the purview of the board to hold off the standing issue, to say to Mr. Ogrodnik on behalf of his client, you want to try again with an application that meets the requirements, assuming the requirements at the time you file the original application still apply, and come back and we'll see where we are at that point. That's a decision of the board. The board can do that. The board can accept my recommendation. The board can do what it has done before, which is tell me I don't fill in the blank and go right ahead and let the application go forward. Whatever application, by the way, that is, that's another issue. If you allow this application to go forward currently, which I don't believe Mr. Ogrodnik's client is asking for, you got to figure out, as the chairman indicated, which application are we handling. So I would say, Your Honor, that those are the options, and it's now the question, leaving aside the multiple arguments that I anticipate will come from both counsel, as to whether or not Mr. Ogrodnik's client is looking for another crack at this.
I would just make one correction for the record, and I could see how these
Only one?
These were can be confusing having all these different applications, but this board accepted jurisdiction of this application and held 8 or 9 hearings. There was never a flag lot proposed. It was a lot not abutting a street. And if you remember, Mr. Bernstein dictated that we have to present testimony, planning testimony, solely on that Section 3536 variance, and we did so. So there was already a determination that at that time, which was a landlocked parcel with a permanent perpetual easement for access, that this board had jurisdiction over that. So I think that
There was a second point to that.
Yeah, ownership.
And that was the other point. And that has continued to be the point. Your client argued that they had the right by the owner to go forward with the application for a flag lot, and the answer was if you wanted to put testimony on. Look, Michael, your client's asking for an adjournment. The board, I think, I'm not speaking about, I think the board might be inclined to consider granting the adjournment, but the board needs to know what it's going to be looking at rather than doing this another in a vacuum. If your client intends to come back with round one, you got all the issues you got to deal with, whether this board has standing or doesn't have standing. And ultimately, whether this board decides or a court decides whether or not this board had standing. Or do we try another option, and this is a rhetorical comment rather than a determination, as to whether or not there is the ownership issue and the variance issue and the flag lot issue can all be addressed without this notion of some form of condominium ownership that frankly, I'm not so sure anyone on this dais is particularly enamored of nor believes can be met. I have no idea what the deal is between your client and the current property owner, but there are ways to address it, I believe, that don't involve some form of condominium association with an application that potentially addresses what Mr. Torriello's client wants, what this board has seemingly indicated at times it might consider. 10% reduction in the building and a few less loading docks. I don't see at the moment the board has made a determination. Obviously, that's a concept you're going to have to decide. Leaving aside what I'm sure Mr. Torriello is going to tell you, which is, I don't know what I'm doing. And it's a standing
No,
issue.
I just wanted to add for the record, I also have just one, I don't want to say correction, expansion. When you placed on the record that the issue is standing, that's one of the two issues. The second issue is whether the changes made require a new application, which even if the board was so inclined, which I've already objected to, but if the board was so inclined to allow Mr. Ogrodnik to place another application, that does not preclude the second issue of your legal opinion that if the change, that depending upon the change, it still may require a dismissal by this board.
It may still lack the standing.
And it still may lack the standing. Yeah, I was
Well,
just,
what I mean by
yes,
standing is
correct.
two-part. One, this board has jurisdiction because the request made are, or two, the application in and of itself is not before this board because the situation has changed in terms of whether or not this is a new application, and therefore with a new application comes whatever ordinances are in effect at the time of the new application, which you all know where they are.
Okay. I guess what I'm just going to, and something that I've said in the past, even with all the case law that was presented, no one has defined to me what substantial change is in a hard metric. I mean, I know there were some, I'm going to say, more qualitative, descriptions, but I haven't gotten a hard on that now with the condo association. I mean, from what I've understood, what condos, there's common ground, common, ownership of that. I didn't see that in that, handwritten agreement. So So with that withstanding, I think, I'm willing to entertain or do the adjournment to see what Mr. Ronick's client comes up with and whether or not, someone can define if it's substantially different, but also I think some of the issues that were, raised originally with ownership along those lines. As I always say, it doesn't hurt to listen, but it doesn't mean we're going to go forward, but I don't see anything that would hurt to listen. But as far as, I don't know what type of timeline you're seeking, because there was none provided. 'Cause you basically have till the end of the year, is the way the time of decision is, and that's probably all that you're going to have available to come back to this board. And I don't know, Mr. Coyce, if we've got,
There's about an hour's worth that Mr. O'Grady's client can have at the last meeting.
right, that's why I said, what do we have available till the end of the year?
That would be there's everything's scheduled, everything's booked out for the rest of this year. For the December meeting, as Mr. Bernstein just said, possibly taking out an hour and having that application go first before the one that's currently scheduled,
Which is Homestead Road.
which is Homestead Road. Thank you.
So I guess we could have that meeting, if his client was ready, would just be a decision of standing.
Right. I think sounds like, and I'm just looking at everybody, if I get some nods or.
Unless applicants willing to extend the time of decision beyond December 31st.
And the applicant is, as we've always been accommodating to that, we would certainly extend time of decision to the end of January, should we be heard in January. And I think, one of the challenges that we face as the applicant in this application is trying to accommodate changes, trying to accommodate the objector, but at the same time, the objector is saying, well, if you make these changes, it's a new application. So
I can appreciate what you're saying, Mr.
All right,
O'Grady.
and I
Okay,
expect-
again, I'm sorry.
Well,
The bays or window dressing, the core request, your client has steadfastly denied moving the detention basin and not directing the groundwater to my client. You have stated in writing you refuse to address that. So my client has never been heard on the core concern. So please stop suggesting on the record or to this board that you're accommodating my client. In fact, you have ignored the fundamental request that he made last May before you filed, when he
Okay.
met with him. So stop it.
No, I just need to address this. You have not seen the latest plans then?
I haven't seen the latest plans. I'm commenting on your false statement to the board regarding prior accommodations. Whatever you intend on doing, I'm not Carmack or I'm not Nostradamus. I'm talking about the actual communications where your client has failed or otherwise refused to address my client's core concerns. And to date, every plan before this board has not only not addressed my client's concerns, you've exacerbated them. You've changed the direction of the flow of the water directly to my client's backyard. And it's not flowing that way right now. You're making it worse.
Mr.
You're not
Torriello.
addressing his concerns, you're exacerbating them.
Mr. Torriello, the latest design of the site plan addressed all the concerns. And if you would like to tell us right now on the record what the changes are that you want, we'll endeavor to accommodate those. But it seems like we're talking about two different site plans. We put the detention basin on the other side of the property. Testify. What is it? What are the changes that
Well,
But
we're
I
not
think
making?
for the
point, it really
purpose-
doesn't matter, because until we see.
Let's solve the problem. We're not sure which site plan we have before this board to begin with, and your client apparently would like an adjournment to try for some variation, whether it is my words, please, wholly new, looks a lot like the last one, looks a lot like the one that started this. I don't know which, but frankly, you're on notice, Michael, that it would make perfect sense, and the board obviously can't tell you to do this, and the board can't direct you to do this, and the board won't, But it always makes more sense if there's no objector and it's only just your client and the board. And don't respond because it doesn't need a response. It's a comment for the purposes of the generic record. Whether Mr. Torriello's client ultimately agrees or disagrees with what you provide is going to be his decision and his situation. But I would agree with objector's counsel. We have no evidence on the record as to what the objector's concerns are, or whether or not your client's plan, whichever one it is, suffices or doesn't. So until we get all of that on the record, I would prefer that we not characterize this as it meets, it doesn't meet, it has met, it doesn't meet, because we don't know that one way or the other. So, Mr. Chairman, what's the pleasure of the board?
No,
Do we need to open to public?
I don't know, do we need to open
No,
public, because there's nothing here right now, so.
no.
I guess first, Mr. Wright, you said you would be willing to extend the time of decision to the end of January of next year.
Yes, sir.
Mr. Coyce, is there anything on calendar, because I know we've been talking about that we.
Well, I think Mr. Coyce and I, Mr. Chairman, had this conversation again this afternoon about trying to get the schedule for next year before this board, before reorg, to avoid, A, what occurred at reorg this year, and B, to try to accommodate counsel and objectors who are not represented by counsel to be available for meetings and not wait until January. I believe the last few years, the board has generally done one board meeting in January. There's the possibility of a second one, which would be the conversion of the usual business meeting to a regular meeting. I would, if Mr. Ogrodnik is willing to carry this matter to the end of January, if the board is so inclined to grant his client another hearing, then we would have to accommodate, and we would advise him either in writing or at a public meeting, because it's not like he's never here, as to what the possible date would be. But that will require, David, that this board have a schedule to.
How would I get notice?
We'd advise you in the same manner.
Okay.
Nobody gets special.
I just want to make sure, no, it was only because you referred to Mr. Ogrodnik appearing here on other
Well,
meetings.
if Mr. Ogrodnik Torriello was to appear and I were to tell him that, I would advise you probably in writing before, at the same time I told Mr. Ogrodnik, but we put it on the record, without you here, the matter is being carried. So in case somebody else other than you and your client and your expert want to be here for the enjoyment, they would all be at least aware of it. But no, nobody's going to get special.
So what is our first meeting date? Just.
Well, we don't have one. Therein lies the issue.
But we have reorg scheduled, right?
Well,
And
reorg,
typically, we would,
we have reorg scheduled for reorg.
right, but what date is that?
January 11th? Is that the date that comes to mind? I'm only going
Is
from
that the
memory.
that's the second?
Second
Tuesday?
Thursday in January. Don't ask me why, if that date is correct, how I know that.
Second, yeah. Well, you have the fourth is,
Oh, here it is, January 11th, 2024.
As I said, don't ask me why I know this. There's too many things I shouldn't be knowing.
Here we have reorganization at 7 and regular at 7:30.
Of which the board has at least indicated to another applicant the consideration to grant that one to them. Correct me if I'm wrong, folks, that was my recollection of their last appearance. Though their extension hasn't gone through the end of the year either.
Right, but do we, which application is that? Maybe we just-
Homestead Road,
Yeah, Homestead Road LLC.
the other Homestead.
Yeah.
And we have another application that we're holding on that as well, because of a time of decision based on completeness.
Well, we could probably do two that, if we had to that night. That's a
Right.
subdivision, it's a subdivision
Right.
application.
It's a minor subdivision.
I think what we get, Mr. Chairman, is Mr. Ogrodnik's agreement to extend the time of decision through the end of January of 2024, with the matter to be continued, of which at some point the board will render a decision on what night that will be. Applicant's counsel, objector's counsel will be advised. I would leave the 11th and the 25th open right now. And then do it once we get a schedule. We can't technically approve a meeting in January without a reorganization schedule. That produces a whole nother set of problems. With Mr. Ogrodnik, with the understanding this board has granted his request not to make a decision, and in exchange for that, his client has agreed to extend it, and that we will come up with a hearing date.
And can I just confirm that at that adjourned hearing date, we're going to have revised plans by the applicant, and we're going to make a decision on the standing issue?
I would assume so, Mr. Radowitz. I would assume Mr.
That's what we're
Ogrodnik.
That's the intent?
Yes.
Mr. Ogrodnik, assuming for the sake of, with what has all been discussed, is it possible, in fact probable, that your client can provide a set of plans to be reviewed by everybody before Thanksgiving?
That's what I was going to suggest.
We'll try to meet that deadline, if not, first week of December.
Well, Thanksgiving actually happens to be early this year. So if not before Thanksgiving, no later than November 30th, which is the week after Thanksgiving?
That's enough time.
Okay, so your client will endeavor to have all plans submitted prior to Thanksgiving Day, but if not, no later than close of business, what is that,
The 29th is a Friday.
Friday, November 29th, no later than 4 PM. Copies to Mr. Torriello, please, as well as to that would give everybody time to review them.
And we're operating under the assumption that the progress that we've made in reducing the size of the building would not be considered a substantial change. The board prefers the smaller building. Now, I understand he has to preserve his argument.
I think, to quote the chairman, I'm not totally convinced, I'm paraphrasing, you'll correct me if I'm wrong, Carl, I'm not totally sure right now what substantial change is. I need to understand it by what I look at. Mr. Torriello is basic, everybody is reserving their legal positions. Mr. Torriello's positions, my position, your position, it's ultimately up to the board whether they decide whether or not it's a substantial change.
Is that the correct legal standard?
The board deciding?
No. Substantial change, because I believe that's a res judicata standard.
That's an argument Mr. Torriello is making. I have not necessarily determined that that's the issue for granting the change in standing, as to whether or not your client still has standing here and whether the application is substantially changed. But we'll take another look at it ourselves internally.
I'll just reiterate.
Based on your arguments and counsel's.
I'll just reiterate, I have not seen a metric that defines substantial, whether it's, whether it's some type of percentage size of change of the footprint or the value of it, anything that has been presented by any objectors or anyone, it's been all qualitative.
Right.
So that's why, and I think even the courts have thrown it back to the boards to make that decision, so.
Well, what I wouldn't want to see is that we spend the next 5 weeks redesigning a plan that's smaller, that's shorter in scale, only to have the board say, well, it's so much different than you don't have standing. That doesn't make sense to me. If you reduce the size of a structure, it happens all the time before this board.
I think,
So,
I think,
I'll-
Mr. Ogrodnik, if there is a concern by your client as to that issue, it even more highlights the need for you to make a resolution with objectors' counsel, because at that point, there's a question of who has standing to make that argument down the road. I don't know that for a fact. And the case law cited by Mr. Ianello, as commented by in my brief, indicates there is some sense of metric, but not a firm sense of metric, like if you do X, it is, if you do Y, it isn't. The courts imply that a 20% change is a substantial change, but do not firmly come down on, yes, it is. Why we love the courts.
But
Right.
again,
But
that's
the
for res
courts-
judicata. What our position is that the standard is, does the quote-unquote central focus of the application change?
And in making this request that you're making, and for this board to consider it, everybody's going to have to roll the dice a bit, proverbially speaking, on where we go. The easiest way out, so to speak, is for this board to follow my recommendation, and we can then march off to Somerville, and you and I both know, as does Joe, that there are no civil judges sitting, and we will be sitting there until 2020, fill in the blank. So I think this is the way out, and we'll have to deal with the rest of it depending on where we are. Your client's got to take, everybody's got to take a certain amount of conjecture.
And again, the courts haven't decided what's 20% of what. They didn't define the unit of measure, in my view.
You know, we look, when an application is denied, oftentimes applicants tweak the plans, adjust the plans to go back. And that's when the board has to look at the res judicata issue. So my position is simply reducing the size of a building, reducing the intensity, does not change the quote-unquote central focus. So I guess there's a question, a legal question on, is it substantially different, or is it the central focus, and what's the correct standard? I'm interpreting what the board is saying today to instruct my client to try to work with Mr. Torriello and his client to, adjust for all the engineering comments and to reduce the size of the building, perhaps more, and to accommodate those requests. If that results in a substantial change and we lose jurisdiction, then you're putting the applicant in a very hard place, because we're trying to accommodate everyone's requests, so.
I think the board will have to determine that when it sees whatever it gets, but, for what it's worth, without, and Mr. Mayu is not here, and Mr. Coyce doesn't do engineering, and I do legal / everything else.
Ultimately, the
Dealing with the outstanding questions and size in accordance with surrounding may be an issue that makes more sense, but I'll leave that to you.
Thank you.
Okay.
Mr. Coyce, you have the document, for Mr. Ogrodnik to sign?
So, Mr. Bernstein, to summarize, the motion is...
Summarize is a motion to
Extend it-
continue this application without further notice to a date and time to be determined by the board prior to December 31st, 2023. The time of decision for a meeting in January of 2024. Time of decision, January 31st, 2024, at which time the board, after reviewing, will deal with the standing issue initially, and then depending on the standing issue, whether or not we go forward with the application. With everyone, the board, the applicant, and the objector all preserving all legal rights that they contend they have relative to the various issues still before this board.
Okay. That may I have a motion.
So moved, Mr. Chairman.
Okay, Mr. Wagner made the motion. Is there a second?
Second.
Mr. Scobo made the second. Any further comments from the dais? Okay, roll call, please.
Mr. Wagner?
Yes.
Mr. Peason?
Yes.
Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mr. Radowitz?
No.
Mayor Lapani?
Yes.
Vice Chair Julian? Yes. Chair Sirachi?
Yes.
Thank you.
Okay. Yep. I think with that, we are coming to the conclusion. Unless Mr. Coyce, any last announcements? I do believe we do have a meeting next Thursday evening, October 12th of this year, starting on or about 7 p.m.
I would remind everybody, this is a continuing application. Anyone who is recused is still recused. Anyone who is not recused, if there is going to be a problem in attending, please advise. I anticipate that this will not be the last night of that hearing either. And we will be facing the same scheduling issue again.
Okay.
So,
So with that, I will entertain a motion of adjournment.
So moved.
Second.
All in
Mr.
favor?
Wagner and Mr. Radowitz.
Okay. All in favor?
Aye.
Aye. We are adjourned. Good night, everyone. See you next week.
8:49.